Ms. Mathilde Trou. You are from the Regroupement des Maisons pour Femmes Victimes de Violences Conjugales. We would ask you as well to be as succinct as possible, so we'll have more time for questions and answers. So thank you. Uh, well, uh, good morning, and I'd like to thank the committee for having invited me. And first of all, I'd like to talk about our group. We have 43 shelters and which assist and shelter women in 15 regions of Quebec. In 2017-18, we have housed more than 2,800 women and more than 2,200 children. We offer 16,000. We have offered 16,000 services beyond sheltering, outside consultations, support for women. We also help women, but also their those close to them, their family, and professionals. We feel that this bill will have a direct impact on women and children who are victims of family violence. This is because violence doesn't end with separation. Quite the contrary. After a breakup, it is at this time often that women and children are killed by the former spouse. Or even in cases where people are in divorce proceedings, or who are separating. There are three very important elements which have to do with this. The first is the codification of the best interests of the child, and this would include the presence of family violence and its effects, which courts should bear in mind. The second is the inclusion of an exhaustive definition of family violence, and we'd like it made clear that this violence does affect women, but we'd like a better definition. And finally, we do commend the obligation on courts to check whether one or other of the parties is bound by a civil protection order. Now, as my colleague said, with respect to clause 16.3 C and I, and you can imagine the kind of situations in which communication and cooperation could be dangerous for women and children. So we would like that there be an exception when there is family violence. Same thing for the conflict resolution mechanism. Several studies have shown that it is not appropriate in cases of family violence, since the balance of power and the ability to negotiate on an equal basis are often absent in cases of family violence. So we would like an exception to be added to clause 7.3 with respect to courts. We would like them to take into account any previous conduct in order to decide what are the best interests of the child, because conjugal violence is such that all actions taken previously have to be used in deciding the best interests of the child. Another very important point has to do with shared custody, because as I said earlier, violence or family violence doesn't end after separation, and when there is shared custody decided on by a court, this means that sometimes fathers can continue to exert control over mothers. So we think that there should be a section added to the bill where it says that where there has been violence, that this be changed. There's also a section or clause 16.21. They often say that the child should be able to spend time with both parents, but there can be problems when there has been family violence. So we would like this clause to be deleted in order to avoid any confusion. And my last point Our various member shelters have noted that there is sometimes a misunderstanding of family violence and how it works with respect to various interveners in the justice system. Some lawyers advise women to divulge the presence of violence, or tell women they shouldn't divulge the presence of violence. We would recommend that there be obligatory training, that it be in the bill, and that it be destined for legal interveners. So that's my presentation, but I would like to point out that the bill as is is something that we'd like to see passed rather than not. Thank you.